Hey everyone, thank you. Thank you for coming back for our MAPI show. Today we have David from CPL Group, CPL
Chaves, Perlowitz, Luftig.
to join us to talk about landlord-tenants issue right now. April 1st is tomorrow, and we have a lot of landlords calling and want to know how to handle the pandemic with landlord-tenant issues. First, David, you want to introduce yourself and your firm?
Sure. Hi, everyone. Hope everyone's staying safe and healthy. My name is David Goldfischer. I run the landlord-tenant division at Chaves, Perlowitz, Luftig. I deal with all sorts of landlord-tenant matters throughout New York City, specifically as it relates to rent-regulated apartments and both free market apartments, DHCR, HPD, DLB, all that fun stuff. So now with the current epidemic we're facing, there's been a lot of issues that have come to the forefront between landlord and tenant, and it's very important that we address these matters now, being that it looks like we're going to be on lockdown for the next couple weeks at a minimum.
Yeah, and everybody is kind of like confused about this senator bill, S1825.
Sure. So I guess jumping in now, I'll just start with the regulatory stuff and some background. In the past, when we had landlord and tenant issues that would come up, we referred to the New York City, the housing code, landlord-tenant law. There's a lot of statutes that govern the way we act in these relationships. Given the current epidemic, those rules are sort of out the window, and the normal guidelines aren't really applicable. We're dealing with something that's unprecedented, and none of us really have any clue how to deal with it. It's not like we just flip open to the New York laws on how to deal with the coronavirus situation. It's not there. So, there's a lot of things that we just sort of have to get together on and work towards a mutual understanding with. It's going to require a level of flexibility on both landlord and tenant. And we have to be, very sensitive to both parties' needs. A lot of people are struggling now financially, landlords and tenants. So we have to be sensitive to these facts. One thing I do want to, be clear about is that we all know there was a 90-day moratorium placed on all eviction proceedings. So if a tenant was in a position or a landlord was working to evict a tenant, they can't do so for at least 90 days. Furthermore, housing court is essentially at a standstill right now. It's basically paralyzed. You can't start and commence a new case now in housing court, aside from a very select few, such as if the landlord's locking out a tenant or there's a serious repair issue. Other than applications of that nature, there are no new cases that are being started in housing court. So that's just important to understand from the get-go.
I want to say something about the lockout. So it's really essential. Please do not lock out your tenants. I know, especially in my community, that if you I'm a landlord, then I have the right to. That's my house. That's the mindset. But it's not. Please, please, please do not lock out your tenants. You're breaking law here.
No, absolutely. And, putting Corona aside, even during, regular times, I would never recommend locking out a tenant. It's a recipe for disaster. It's something that courts look down upon tremendously. And you never, ever want to do that. Not a good idea in any situation, particularly the one that we're going through right now.
Okay. So I just want to ask you a few questions that we have together with.
Please.
All of our landlords asking. So can the tenants to evict it if there's a pending case?
So good questions. All cases are on hold right now. So nothing is going further. So if you had a pending eviction case, that case has come to a full stop for the time being.
Okay.
How about, has New York State issued a freeze suspension for the monthly rental payments?
Great. So let's talk about that. Before I get into the rent payments, we all know there was a directive on the state and federal level to hold off on mortgage payments for 90 days, right? That doesn't mean that the payments are forgiven. It means that there's a freeze. So after the 90-day period is finished, they're sort of put on the back end of the mortgage payment schedule, and then they'll have to pay it back. And I know late fees, online fees are all put on hold, as well as no negative reporting to credit bureaus. Now, in regard to rent payments haven't come through the pipeline yet. There's been no issue or directive by the state as far as rent payments are concerned. However, there was a bill that was introduced last week by State Senator Michael Gianaris, Senate Bill S8125A, whereby it would provide a 90-day freeze and suspension for rent payments on both the residential end and the commercial end. So if there's a tenant that lost their job or entered into financial hardship due to the corona situation, they would have 90 days to sort of suspend their payments. And the same goes for a business that had to close due to the current situation. Their rent payments would be frozen or suspended for 90 days. Now, again, just one thing I want to reiterate is that these payments aren't forgiven. Now, they're going to have to be paid at some point. So that's just something that tenants should keep in mind and be aware of. Furthermore, the bill, what it also did, or what it will do once it is signed into law by Governor Cuomo, hopefully shortly, what the bill would do as well is that if there's anyone, again, residential or commercial, who has a lease expiring during this 90-day period, they would automatically get a renewal from the owner. I mean, the owner would be obligated to offer them a renewal at the same exact rate. Now, the one thing the bill does not explain is how long of a renewal, meaning is it a 1-year renewal, is it a 5-year renewal, what sort of duration is there? So my hope is that between now and whenever the bill gets signed into law, the state legislators can sort of work out these details and clarify as to the duration of the renewal that the owners will be mandated to provide to the tenants.
Okay, so right now, you said it's freeze, it's suspended, it's not free. So like a lot of like interpretation out there, I know people think that it's free, like it's forgiven. It's actually not. It's not.
No, absolutely not. And again, as of today's date, sitting here March 31, there hasn't even been a suspension yet. So as it stands right now, it's business as usual for tenants and rentals. That being said, inevitably, you're going to have clients who are landlords that are going to be approached by tenants saying that they can't afford the rent. Unfortunately, it's just the reality of the situation. It's going to happen. I'm getting calls every 10 minutes about this. So what I've been suggesting to everybody is that there has to be an open line of communication between both landlord and tenant. If a tenant can't afford the rent, let the landlord know now. Don't wait for the landlord to reach out and saying, hey, where's my April rent? Get ahead of it now, have that discussion, and work something out. Another thing I have been advising tenants is that if they cannot afford their monthly payment, they should at least try to pay the landlord something. Meaning 50%, 25%, something they can afford to give. Obviously, if the tenant's literally living hand to mouth and, it's going to come down to feeding their families or paying their rent, obviously, you go ahead and use that money for more essential needs. But again, it's a very good, it's a sign of good faith from the tenant if they could at least pay something, given the financial circumstances faced on both sides.
So if the landlord, it's a landlord as an individual, like if the landlord decide to forgiven the half months that you owned, or you only pay like for April because you're not opening, or the landlord decide to defer that half a month, so everything you suggest to be in writing.
Yeah, absolutely. If there's any change to the rent schedule, or if a landlord's forgiving rent, definitely put it in writing. You don't want to be in a situation where there's misunderstanding a few months down the road from now, where one party remembers the situation one way while the other remembers it in a different way. You want to have everything in writing, and you want to take care of that now. Don't wait, just do it now.
So when you say in writing, like email, text, is that considered as in writing, like even with a text message?
Listen, I think nowadays, we have to be mindful that, it's not as easy as it was to sort of go ahead and send a certified letter. My office, what we usually do in such situations, we usually send out certified letters along with proof of mailing. It's a little more difficult now, obviously, to go to the post office and get a letter out. So emails, would suffice. Just make sure both parties are clear on exactly what the communication is. You don't want to leave anything ambiguous. You want all the terms to be crystal clear for both parties.
Okay. So for the renters, is there any kind of like relief the renter can expect in the event today that they really cannot make the rent?
Yeah, so again, hopefully this the Senate Bill S81258 goes through. That'll provide them with a 90-day passage. I suggest that a lot of tenants reach out to the landlord if they are facing hardship, try to work something out between each other. There hasn't been any specific relief outside of the rent suspension for tenants as of today's date. However, the situation is fluid. Everything's changing day by day. We have no idea what tomorrow is going to bring. The one thing landlords should also know is that they have very little leverage in this situation. Meaning, like I mentioned at the outset, there's housing court is essentially closed. You can't commence a non-pay case right now. And even once the courts open back up, we don't know what the situation is going to look like. I mean, they might open 3, 4, 5 months from now, who knows? And then there's going to be a flood of cases hitting, housing court. how are they going to deal with it? They're going to have to come up with some sort of formula. They're going to want to deal with like the more egregious cases first, and then deal with some of the non-pays. So I wouldn't, if I'm a landlord, I wouldn't resort to thinking, oh, if the tenant doesn't pay, I'll just sue them in court later. No, try to get a agreement done with them now instead of waiting for later, possibly resorting to legal action.
Okay, but I know that you also suggest to kind of like, if this, like, they just not paying, like they're not even gonna work with you, you suggest to actually file the 14 days notice anyway.
Yeah, so the way, again, putting aside Corona for a second, when you want to start a non-pay case, you have to serve the tenant with a rent demand and then a 14-day notice. Those notices can still go out now. There's a bit of a question as far as whether or not process servers are considered to be an essential business. I think the Association of Process Servers in New York put out an email from the Department of State where they confirmed that they are essential. So I think there are still process servers out there that are functioning and serving notices. So if you go ahead and serve the 14-day notice now on a tenant that's not paying rent, it will save you 2 weeks later on when the courts do open and hopefully they start hearing cases again. You won't have to go through the 14-day notice process then. You'll be able to go straight and serve the tenant with a petition to appear in court. So you'll sort of save yourself those 2 weeks if you go ahead and serve the notice now.
Okay. For some reason, I always thought that it was a 30-day notice that you serve to the tenants.
No, for non-pay cases, it actually used to be before June of last year when the state revised all the rent laws. It was actually a 3-day notice. Yeah. And the 3-day notice would change to a 14-day notice. So that's really where we're at now. But again, even non-pay cases for landlords are notoriously difficult to win. When landlord and tenant go to court for non-pay, the landlord's always at a disadvantage, especially in New York, where the housing courts are notoriously tenant-friendly. So that's another thing that the landlord should be mindful of before just resorting to a non-pay case. I'm always a favor of working things out amicably between the tenant, even if the landlord's only getting a fraction of what they are, what they think they should be getting under the lease.
Okay, and then is it also like sent out on the 1st of every month with these notices, or is it? It doesn't matter.
The notices can be served whenever. The notice can be served whenever. But the important thing is that when the tenant is 5 days late to rent, then they have to wait for that to serve the rent demand. There's a rent demand and the 14-day notice. So the landlord has to be on top of all these different rent demands and notices and make sure they get them out on time. But right now it seems like timing is not an issue because no one's running to housing court to start a case, unfortunately.
Yeah. So right now I think that we just really suggest everybody to work together to pass this hard time.
Yeah, it's very important to take a collaborative approach, and like I said, communication is key. Speak with your tenants, speak with your landlord, and we'll get together and put things on email as well. It's very important.
Okay, and then what happens if a tenant signs a new lease and they're about to move in, but they're not able to move in? Let's say it's lease is starting tomorrow, and they're not able to move in by tomorrow. So what happens then?
Yeah, so another very common situation that's happening all across the city. Tenants, either it's because the building restricts it, or they're someplace and they don't want to travel to New York. There's a lot of issues with tenants taking possession of apartments for leases that they sign. Again, try to reach out to the landlord. The best case scenario is that they can push back the lease start date, maybe amend the lease and start it in May, June, whatever it may be. Another option is maybe if you get some furniture in there, start setting up the apartment if possible. Another option I've seen is maybe offering to pay the landlord, 20% or 50% of the rent until you could actually take possession. I've also seen the other extreme of tenants is trying to break the lease, in its entirety, and landlords are left holding the bag because they're waiting for a tenant to move in. Now the tenant's refusing to move. They don't even want the apartment in 6 months from now. And the landlord has to start marketing the apartment again, which is, virtually impossible to find a tenant now. So, a lot of people are finding themselves in tough positions. The best case is if you have two parties that are just open-minded and happy to work together and figure something out. But a lot of cases are not like that, and we're just left with people abandoning leases and landlords just getting stuck.
How about those like the landlord that, let's say my lease is expired in March, and do you suggest landlord to issue like a short-term renewal to the tenants?
Yeah, absolutely. Unless it's a stabilized apartment where the landlord has to offer a 1 year or 2 year renewal. If there's a lease that's expiring like at the end of March or even at the end of April, make sure to have that discussion with the tenant now. If the tenant can't move and they have no plans of going anywhere, get them under a new renewal. And if you have to do a short-term extension, a 3-month, a 6-month, whatever it may be, you can go ahead and do that. There are creative options that we do all the time for our clients, where you build in different termination options under these short-term extensions, whereby everyone is happy. The thing I always advise my clients against, you don't want to end up in a situation where the tenant becomes a month-to-month tenancy. And that occurs when the tenant remains in the apartment after the lease expired. Then the lease, transfers to a month-to-month tenancy. It's never a good idea to have a tenant in that situation. You want to get them on a proper lease. So again, if you have landlords that weren't planning on renewing leases, they might want to reconsider that and say, hey, listen, tenant's not going anywhere anyways. I might as well offer them a short-term extension. Make sure we have a proper document in place to govern this landlord-tenant relationship.
So you mentioned that it's never suggested to be in months and months. Is there, because I never thought of that way. Like I thought that months to months and short term there's no much difference. Can you go into more of that?
Sure. So month to month, again, month to month occurs when a tenant stays over an existing lease and just doesn't leave, for whatever reason. The landlord forgot to give them a renewal, or the tenant just can't go anywhere. Under that terms, the lease is sort of the default lease, meaning all the terms that were under the prior lease apply now. I'm a fan of just having everything updated. Get them on a new lease now. Because a lot of times landlords want to renegotiate the terms. They might say, oh, my initial lease let you have a pet. Now I changed my mind. I don't want you to have a pet. I want to raise the rent by 3%. There are a lot of different changes that could be made. They want to get additional security deposit if it's allowed. So there are situations where a landlord might want to amend the terms, but they can't do so if the tenant's on a month to month, because the initial terms by default still apply.
Got it. So even with the extension, for a 3-month extension, 6-month extension, it's new lease with new terms, pretty much. They have the option to do that. Okay. For
sure. Again, you have to remember to give proper notice to the tenant. The notice laws depend on how long the tenant's been in the apartment. So if they've been there for 1 year or less, 30 days. Between 1 and 2 years, it's 60 days. And if it's 2 years or more that the tenant's been living there, you have to give them 90 days notice. So that's just one thing to keep in mind. That's very important.
Okay, so I just spoke to had a case that this landlord that decided to forgive half of the months, but because he feel like he's, let's say 3 months that he only collect half, then that's another a month and a half extra for the rest of the lease term. But it's case by case. Some landlord decide to do that. Some landlord decide, I still want the rest of the rent, like making payment. So those things that like the landlord and tenants agreed on, so everything, do they draft another kind of agreement on the side, or it just those emails and text message is enough?
Again, nowadays it's hard, given the current situation, it's hard to get a written letter out in some cases. I would certainly draft an amendment regardless, amend the lease saying, listen, these months, April through June of 2020, the rent will be at a reduced amount. Because again, you don't want to be in a situation down the road where the landlord says, hey, you owe me this money for this month. The tenant says, no, we agreed on a reduced price. And the landlord says, no, it was only for these months, not those months. So you don't want to leave anything open to interpretation. That's very clear. So the best case scenario is if you have both landlord and tenant sign off on a mutual document, which sort of outlines all the terms they're agreed to. If you can't do that, email is, I guess, the next best option. Just make sure both parties are in complete understanding of exactly what the terms are.
Okay. So where you can use some kind of like software like DocuSign or anything like that.
Yeah, that's definitely the next best option.
Okay, so there was also some news articles. There was one specifically on Bloomberg that was talking about security deposits being used towards rent.
Yep. So yeah, I'll discuss that. Sure. So one important thing to keep in mind regarding using the security deposit as rent is that is not a law right now. As of yet, it's not a law. It was a suggestion by an elected official. Now, if a tenant is in, dire straits, they can't pay anything for April, and they're willing to let the landlord take the security deposit, great, then the landlord should go ahead and do that. The one thing I would advise there is that if that does happen, they should also put it in writing that their landlord's taking the deposit in exchange for April's rent. Because again, you don't want to be in a situation where the tenant's vacating the apartment a year, 2 years down the road, and they say, hey, where's my deposit? And the landlord said, you used it for rent in April of 2020, and the tenant said, no, I didn't. You don't want to be caught in that, sticky situation. So make sure to put that in writing. And also, it might be a good idea for the landlord also to specify that he's using security for this month's rent, but a couple months down the line, when the tenant gets back on his feet, I'm going to request you fund an additional deposit now, because it's not a good idea for the landlord to be left without a deposit. So these are a few things to keep in mind if this does get signed into law, or if it becomes prevalent where landlords are taking deposits in exchange for rent. So these are definitely things you might want to advise your clients on as well.
Yeah, because I have cases that like the landlord agreed to the tenants to use the security deposit at the last month's rent. Then when the tenants move out, the apartment's a mess. Then you have no you basically lost your leverage of.
Yeah, you have no recourse.
Yeah. So I usually suggest them not to, but in this difficult time, I guess like you said, they can use it and maybe replenish it after everybody gets back on their feet.
For sure. I would definitely view this option as more of a last resort. If the tenant's really stuck and the landlord really wants to get something, then yeah, sure, you take the April rent. Yeah, I'm not sure why the landlord would be in a rush to do so, meaning then what happens with May rent? You know what I mean? What will change between now and May? So I guess, it's up to the landlord. It's their discretion at this point. But regardless, they should make sure that everything is documented. They paper this. There's a written communication or, an email between the two parties outlining exactly what their intent is.
Okay. Is a mover considered essential? Because like I have people still move in and move out. So like they kind of like having hard time to find movers out there.
Yeah. So from my understanding, movers are essential. That being said, a lot of issues that are occurring are independent of movers, meaning a lot of buildings aren't allowing moving companies to come in. I had a client call me today. He's having issues with his tenants moving in furniture. They don't let furniture deliveries. Anything that requires a freight elevator, they don't allow it. So these are, even if the moving company is in service and the tenant finds a moving company that's willing to bring their items, make sure to clear it with the building beforehand, because you don't want to be stuck sitting there and the building doesn't let you use the freight elevator or whatever it may be.
Okay.
Got it. Thank you so much for answering all of these questions.
Sure.
Is there any relief for the landlord? Because there's like always two parties, right? Like there's the renters and there's tenants and there's landlords. Landlords still stuck with all of the bills, like water, tax, real estate tax. They still have to pay. There's no nothing come off about the real estate tax. And in New York City, the commercial real estate tax is really a lot for the landlords. And is there any relief for the landlords to kind of like help them out?
Yes, that's a great point. So a few things. First of all, a lot of the landlord advocate groups such as CHIP and REBNY, they've been lobbying hard for the state to reduce the taxes once they come out with the new bill April 1. So hopefully a lot of landlords see a reduction in their real estate taxes for the upcoming fiscal year. That's the first thing. The second thing I saw is that Fannie Mae actually said that they will waive mortgage payments for 90 days for multifamily landlords who are suspending evictions for non-payments for their tenants. So if you're a multifamily landlord in New York, you automatically fall into that category because evictions are put on hold for now anyways. So you definitely are suspending all evictions. So you might be able to take advantage of that 90-day suspension of your mortgage payments as well.
Okay, so and it's case by case for how they deal with their financial provider, which is their bank.
Exactly. Yeah, you definitely want to speak to your bank beforehand, for sure.
Okay.
But again, the situation's fluid. Every day there's something else coming up. So the hope is that, as this carries on to April, the elected officials get together and they pass some legislation that helps everyone deal with this in an appropriate manner.
Yeah, and it is tough time for everyone, like for the landlord and for the tenants. So like, I don't think we can emphasize enough to have them work together to have, to pass this hard time.
For sure. It's essential. It's crucial. Both parties have to work together. And again, just be sympathetic. We're all going through tough times, and everyone's facing the same set of challenges. So let's work together and try to make life a little easier for everyone.
Okay. And and another question is, how does people, like, if they want to reach out to you, what's the best way to is there email, phone number?
Sure. Yeah, either one. My email is My initials, D, Z as in zebra, G as in Goldfischer, at CPL, stands for Chaves, Perlowitz, Luftig, cplawfirm.com, all one word, or they can reach me on my landline, which goes straight to my cell, 212-897-5691. Reach me at any time, cell, email, whatever it may be. I'm happy to answer any questions your clients may have.
Thank you. Thank you so much.
My pleasure, guys. Thanks for having me. Best of luck. And if you need anything, you know where to find me.
Thanks.
Take care, everyone. Stay safe.
Thank you. Take care. Stay safe, everyone.
Bye-bye.
Bye.
Bye.